Today's presentation, Ethical Considerations in Software Audits. Your presenter, Keli Johnson Swan, is an associate attorney at intellectual property and technology law firm Scott & Scott, LLP, located in Southlake, Texas. Keli is primarily focused on software licensing and copyright infringement issues. She advises clients in a variety of industries to ensure software license compliance and to develop strategies for maximizing the value of those licenses. I'll turn this over to Keli now.
Thank you very much, Anita, for that introduction. My name is Keli Johnson Swan, and today I will be discussing ethical and legal considerations for software audit. For the agenda today, we're going to have a generalized background on what is a software audit for those of you who are unfamiliar with the process. We will go into details about the types of audits and how they are initiated. Then we'll discuss the focus of those audits. What are the primary goals behind the auditors? What are they seeking, and what is the end result? Then we will discuss the audit process itself, which can be lengthy and burdensome, and we'll discuss the differences on how you can conduct an audit inventory, which will involve how you can protect that information and good strategy decisions for how to protect privileged information during the course of the audit. We'll also discuss how the best ways you can manage and collect entitlement information, since part of the audit process involves collecting this information to prove ownership of the software licenses in order to avoid potential copyright infringement claims. We will also do a brief refresher for all the attorneys on attorney-client privilege and work product privilege and the elements involved in each of those and how you can assert those to cover software audits. In addition, we will also talk about the exceptions to attorney-client and work product privilege and how they can apply to how you can conduct the audit and strategy related to how to submit the audit results. We'll also discuss briefly recent privilege decisions for both attorney-client privilege and work product privilege. Dalby Bain Capital Partners is a good outline of the elements that are required for attorney-client privilege. In addition, for work product privilege, we'll talk a little bit about the United States v. Textron and subsidiaries to discuss what is required of work product privilege, which varies a little bit across each jurisdiction. For key litigation cases, the most important one we'll discuss today is the Columbia Data Products, Inc. versus Autonomy Corporation. That is an ongoing litigation case, but a decision in December of 2012 was very significant for privilege assertions in software audit processes. We'll also briefly talk about Caballero v. United States, which involves an assertion of privilege for financial audits related to a merger and acquisition. Further, we'll talk about the role of Rule 408 interim confidentiality agreements and how those can be used to protect information in the event of litigation if settlement is ultimately not reached. Finally, we'll discuss key settlement provisions. We'll talk about the strategy related to how you can go about amending the provisions and negotiating those terms with the auditing entity in order to have the most favorable result for your client and keep the most essential protections in place for a final settlement. In addition, we'll discuss record retention policies. Those policies have a wide range, but we'll make recommendations on what those policies should contain and how they can affect the process of software audit. Further, we'll talk about negotiating license agreements. Many of the standard form agreements aren't very negotiable, especially when you buy small-scale products. But if you're buying on a larger scale through larger software publishers, there may be some bargaining power with negotiating the audit provisions in those agreements. Finally, we'll talk about how to manage future software compliance to avoid potential copyright claims and software compliance issues in the future going forward on a regular basis for companies. What is a software audit? There are three main types of software audits. First, there's an internal audit. These are typically conducted by a software publisher's compliance team in-house and separate from the legal team. Different publishers go about this different ways, and there are different types that are initiated by different software publishers. For example, Microsoft often will send out a software asset management request to companies directly to their IT department. And this process is simply something where they request information related to their network to ensure that they have the proper licensing and to offer to sell them any additional licenses that they may require for their needs. It also typically includes a penalty for past royalties that are due. The problem with a lot of our clients they encounter with this process is sometimes the IT departments don't think to involve legal or management, so they'll exchange information with the software publisher directly without processing it through upper management and without any of the protections of privilege or a confidentiality agreement. This is a little bit dangerous because if there's ultimately a dispute over whether there are any copyright infringement claims, that information can later be used against the client at either in an ultimate settlement or at trial. In addition, there are different ways. Sometimes an in-house software publisher's legal team can submit an initial audit letter to a client, and that is seeking copyright infringement information and claims for potential damages. They have a specific process that they go through for the audit, and they are seeking to determine whether all of the software involved on someone's network is properly licensed, not just by the actual count, but by the type of licensing. For example, whether a server has the appropriate number of virtual licenses for the instances it is running. In addition to the internal audit, there is the attorney-initiated audit. Sometimes these result from an in-house compliance team audit that is unable to be resolved if both parties come to a standstill. Sometimes they'll involve their outside legal counsel to get involved and send the company a letter. Typically, this letter has a specific date. It's a spoliation of evidence letter that requires that the company does not make any changes to its network or its software installations and preserves the evidence in the event of litigation. It is important to pay attention to the date of this letter because that is the date that the auditors are focused on for determining when copyright infringement might have taken place. And it also is important to determine the run of the statute of limitations, which is 3 years prior to discovery. Finally, the last method of conducting a software audit is initiated by either the Business Software Alliance or the Software and Information Industry Association. These two entities have the power of attorney to represent a number of different software publishers, ranging from Microsoft, Intuit, Adobe, Autodesk, and many others. They are specifically sending out information that they received often from anonymous tips. They have a separate, each of these entities have a separate website dedicated to offering a reward for any informants who are able to successfully give information on companies engaging in copyright infringement. Often they will pay out these rewards if anything is recovered in the event of actual software discovery, the software compliance issues is discovered. It is somewhat rare that they will pay out the maximum amount that they list on their website, but that is attractive to people, and often our clients find that their disgruntled employees find this attractive and sometimes submit false reports based on their history with the company and based on their desire to obtain a reward. Unfortunately, once this process has begun, like any of the other audits, however they are initiated, once the audit is initiated, you can't stop the ball rolling. So companies traditionally have to comply with the audit process, which can be a little bit burdensome and expensive and require a lot of time and effort on the part of both management and IT departments. The focus on these audits primarily are all focused on obtaining information related to copyright infringement claims to determine whether or not there has been copyright infringement, and if so, what are the damages and how they are calculated. Calculating damages is often a highly disputed point. The BSA, SIA, and the auditors initiated will often provide settlement damages calculations based on the MSRP value of the products multiplied by the number installed that they believe are unlicensed, and then they apply punitive damages, an arbitrary multiplier of 3, and they add their own attorney's fees, usually in the amount of $5,000. Many of our clients are confused, and they have concerns about why it's calculated in that manner. It's simply an arbitrary way that they calculate it. Were they to go to court, their numbers would be slightly different. They can use statutory damages instead, but their process specifically for settlement purposes is using those numbers. Many of my clients have argued that market price should be used instead of MSRP value. In addition, the auditors typically apply a penalty for the MSRP value of all components of any suite. For example, Adobe has creative suites that have multiple components, and they calculate settlement damages by applying the MSRP value of each component and multiplying that by the number of installations instead of using the MSRP value of the suite as a whole, which is a much smaller price. In addition, Microsoft is the same way. For any Microsoft Office installations, any suites, they will break it down by component and assess the MSRP value that way. We currently have litigation pending in New York on this very issue of compilation and whether or not you can calculate damages based on simply the compilation as a whole, the suite, or the per work. Our argument is that you should only be able to recover damages for the compilation as a whole, and that one work is a compilation. That we have not yet received a ruling on that. That'll have a significant impact, we believe, on how those calculations are made in the future if that's favorable to us. For future software compliance, that's another focus of the audits. What they are looking for and what they often require in their settlement agreement are software use policies. So part of the settlement agreement will often require the companies to issue to all new employees a software use policy outlining what is required for installation purposes, what is required for licensing, and how to generally abide by the terms of each of the license agreements. It is important for clients and customers of software publishers to make sure to educate their employees on how best to go about this process, and that includes anywhere from what you install in your network to making sure that when you upgrade a product, you delete any remnants of older products to prevent multiple installations from being installed during any one time. Also, for management oversight, it's an important aspect of future software compliance. Many of our clients also decide, after discovering any sort of software compliance issues, that the best method of control is to simply have an administrator lock down access to installations of software products. So they prevent installations by employees altogether, which makes it a little bit easier to manage in combination with routine audits to determine whether or not they have properly licensed software on their network. Finally, from the software publisher's perspective, at least when they're conducting an audit directly with the customer, they are also looking at a continuing business relationship, especially with their large-scale clients. They understand that their clients have spent a lot of money on these products, and they expect to keep their clients, and they understand that even though they're assessing these penalties, they want people to continue to purchase their products and continue to have a relationship with them because it's financially beneficial for the software publishers. However, unfortunately, this sometimes gets lost in the process, any goal for continuing business relationships, because a lot of our clients find that the audit process is so expensive and burdensome that they decide that they're no longer interested in continuing a relationship with the different publishers. Some of our clients decided to go to open source software instead of using Microsoft Office products simply because they were turned off by the whole audit process. Others have tried to use different types of CAD products instead of Autodesk after experiencing an audit similarly. So it really kind of just depends on how a client views the process and whether or not they're willing to continue that relationship. Often, software publishers also understand that with many of their products, there is no viable alternative in the market, so they know that regardless of how they treat their customers during an audit process, it is likely that they'll continue to use their product just out of basic necessity. The audit process itself can be a little bit complicated and often expensive. A lot of times companies do not have the resources, whether personnel or money or just the time and effort it takes to fully conduct an audit of their network, especially if they're not in a position where they conduct routine audits. Two ways really you can conduct an audit. One is in-house. The company can conduct their own audit. They can use third-party auditing tools. These can range from any that you can purchase versus anything that you can download for free on the internet. They can run a scan of your network and generate a report of everything that's installed on each computer. There are some free auditing tools. A lot of our clients in the past have used either SpiceWorks or Bellark. One thing to note is that Bellark recently changed its license agreement, and for commercial use it requires a fee to be paid for the licenses. So it is important when you're searching for free auditing tools, you're making sure to read the license agreement to make sure that it's appropriate for the setting that you're using it in. In addition to third-party auditing tools, software publishers sometimes request that you use their own scanning tool. Autodesk has one. It's called AIA. This tool scans the network and generates the raw data directly back to Autodesk. In addition, they have what's called phone home technology on their newer products, that the products are actually generating reports silently and without any sort of oversight by the customers directly back to Autodesk to report what's installed on each network. In addition, the customer can obtain a custom scanning tool to tailor it to the better needs of their network depending on the size and scale of the operation that they're running. Finally, one option that many other people find valuable, even though it takes a little bit more time for smaller companies that have maybe less than 20 computers, sometimes it's just easier to have a person manually check each computer, their registry, and determine what's installed on that computer. With any of these scanning tools, you always run the risk of having false positives. So it's really important that someone who's familiar with the network is able to review the data carefully and eliminate any false positives. For example, scanning tools pick up express versions or free versions of free software that are often reported as full versions of the software. And the risk is that if you are submitting your data, your raw data, directly to a software publisher, first, it's not protected and it's not privileged. And unless you have a confidentiality agreement in place, it can be used at a later point against any of the clients. So what you're looking at is a risk that it is inaccurate and it's not protected. And so it could artificially inflate your potential exposure with the false positives. That's why it's important to carefully review it and ensure that the report is completely accurate, because once it's submitted, it's difficult to convince the auditing entity that a mistake was made and that you need to revise the installation numbers down. There are also the option of using a third-party IT consultant. They can use many of the same methods listed above for the in-house audit. With the third-party IT consultant, the challenge with that is that often people use a third-party IT consultant without obtaining a confidentiality agreement. And the concern is that that material could be used and could be discoverable. It's unlikely that it's going to be protected by any privilege. Whereas, for example, if you hired a law firm, we actually offer our own custom scanning tool that runs directly on a client's network using an administrator access and runs silently and reports all of the data directly back to our servers. So essentially, we could arguably claim that we have both attorney-client and work product privilege, whereas situations where you're using a third-party IT company may not be able to claim that. And in the event, if you go to litigation and they're subpoenaed, they may or may not notify the party who is being sued before they just submit that information. They won't likely know to have a motion to quash or claim that it's confidential. So you run the risk of having your data, raw data, elsewhere on someone else's servers that could potentially be discoverable. In addition to the actual auditing process, record retention policies are very important. The auditing entities, no matter who initiates the audit, will expect that in order to prove that you own all of the software installed on your network and there's not engaging in any copyright infringement, you should be able to provide a dated proof of purchase listing the product and the purchase price and the company name. Now, some of our clients discover that they purchased really old products and they just didn't keep the record because the product was purchased 10 years ago. To the auditing entities, they are not concerned with how old the product is. They expect you to permanently keep all records related to software products that are installed on your network. We have had a few clients who had record retention policies that was their policy to get rid of documents after 3 years or 3 to 5 years, and so they had no records at all of many of their older products. This is a challenge because the auditing entities only accept the dated proof of purchase, and typically it's not very persuasive to submit the record retention policy. That's why it's important when drafting a record retention policy that software installations and software licenses are kept separate and apart from any other records that might be destroyed on a regular basis. In addition, we have some challenges sometimes with vendor records. Some clients like to use local vendors instead of going to a major retailer to purchase their computers. I've had clients in the past who simply went to trade shows and bought parts and then assembled their own computers and then installed operating systems or software after they had built the computers themselves. The problem with this is it's difficult to produce a receipt or entitlement for that product when you build it yourself unless you keep good records, unless you demonstrate your purchases. Also, some clients tend to purchase from local vendors that have pre-installed operating systems or software, but the receipts and records do not reflect that software. And sometimes they've discovered that it's difficult to get that information from the vendors who may or may not be willing to provide it, even to assist with the process of the audit, which means that they will not receive credit for those particular instances and have penalties assessed for those operating systems or products that they can't prove that they own. It's very important to make sure that any vendor that is used is an authorized reseller of the product. Typically, you can find this information on a lot of the different websites for individual software publishers where you can search in your area for an authorized reseller. We typically advise people not to use eBay because those often contain a lot of illegal software that are being sold. Usually, the auditors are looking at whether or not the purchase price is less than 80% of the MSRP value, because anything less than 80% is usually a little bit suspect, and they question whether that's a legitimate license. Some vendors that people have been able to use successfully that are fairly good at maintaining records and generating a purchase history are CDW and Dell. CDW can often generate a report. It's not all-encompassing because it is limited on the years that it goes back. So some clients are not able to get everything, but they are able to obtain information on a lot of the purchases they've made if that's who they use. We can usually submit the CDW report as proof of ownership as well. For Dell, Dell has a couple of different ways of tracking their information, which is typically very helpful. For larger scale clients, they can generate a D3 report, which generates all purchases made through Dell from that particular company. Many of our clients have also experienced a little bit of problems with D3 reports and getting complete and accurate information. Sometimes information is simply left off that report. So one way to supplement it is using these Dell service tags. These are alphanumerical codes that are contained on each individual machine. And so you can take these numbers to Dell's website and plug them in and generate a report of everything that was installed when that computer or machine was originally shipped. And we have been pretty successful at being able to use that as proof of ownership of that particular software. For attorney-client privilege, I understand that many of you are very familiar with this, so this is kind of a brief refresher just for the purposes of applying it to the audit process. You want to make sure that with your client, the communications between the attorney and client are not only kept confidential, but they're made for the purpose of obtaining legal advice specifically. So once an audit letter is received, all of these communications between the attorney and the client regarding strategy for dealing with potential copyright claims can be protected as long as they're not disclosed to a third party. There are a few exceptions to that, but primarily you're not going to be able to protect the information if it's disclosed. Anything regarding the copyright infringement claims and also regarding software compliance, which includes the audit materials, the different licensing on many of those communications, may be protected by the privilege. It's something that you're going to have to assert in the event that that information is sought to be discovered, either during settlement or during future litigation if you're unable to reach settlement. The privilege is held by the client and not by the attorney. So it's the client that has to assert the privilege. Usually this is done in different manners, but typically during the discovery process. Usually this is not something that comes up during necessarily settlement negotiations. It usually is something that really comes up in the event that settlement falls through and you end up in court, which is not often. Many of these cases, I would say the majority of them, end in a settlement of some sort. The only exceptions are when the auditor is either relying on information that is inaccurate and is artificially inflated, or when the parties simply cannot agree on a number that makes sense and a number that they can both come together on as far as the final settlement payment. That's usually the hang-up. Minor provisions of the settlement agreement usually can be ironed out. For work product privilege, there are 3 conditions that have to be met to establish whether it's a work product. It has to be a document or a tangible thing. The material has to be prepared in anticipation of litigation. And this particular element is the key to a lot of the privilege assertions. And it does vary from different districts. Some jurisdictions have a slightly more narrowly defined test, and others have just the simple anticipation of litigation that's open to interpretation. The materials must be prepared by or for a party or by or for its representative. And the rule does allow parties' representatives to include an attorney, consultant, surety, indemnitor, insurer, agent, but all 3 elements still have to be met. The key with the work product privilege, there's a lot of case law out there regarding auditors, specifically financial auditors. There's not a lot of case law regarding specifically privilege related to audit results from a software audit, with the exception of the one we're going to discuss with Columbia Data Products. These are important considerations because there's an argument that can be made for strategy decisions on whether the party's representative includes that auditor and whether that information comes under the protection of the work product privilege, which is pretty important, especially when you have a situation where settlement has fallen through and you're in litigation and the auditor is seeking all information or all documents or records where you generated reports, for example, the raw audit materials or any other audit results from any of the scanning tools. You want to try to protect that information as much as possible and make sure that the elements are met for privilege to be in place. It has been the case that a lot of times that this privilege is not necessarily going to protect everything that you construct in the course of defending against a software audit or just a routine audit. Sometimes if you're looking at a business record, then the court will view it as a business record instead of in anticipation of litigation. That's sort of the key turning point in determining whether that's going to be protected. The work product privilege applies to mental impressions, opinions, or conclusions, or legal theories. It also includes the raw factual data, and that is the audit results. That's the prep materials that you have for going through and determining whether there are any copyright infringement claims, and that's also what you'll be using to determine whether or not there are any potential copyright infringement damages resulting from the course of the audit. The work product privilege is not absolute. It can be discoverable if they're able to show a substantial need or the information contains information that is unable to be obtained in any other way. Now, obviously this rule, like I said, is not absolute, and so you can't simply rely on the work product privilege to protect your information, which is why we'll discuss the importance of confidentiality agreements as well. The primary purpose test, like I said before, was anticipation of litigation, and this is really the key. The documents created for a business purpose are not protected instead of the documents created for the legal proceedings, and that is something that courts have really been split on, what is created for a business purpose and what is created for legal proceedings. So often look to communications regarding the purpose behind it. For example, if you have a situation where you just do routine audits and you have routine audit results, and that's something that you do over the course of your business just to manage your own software compliance, that won't be considered protected because it's not in anticipation of litigation, even if between your last audit and your next audit you receive an audit letter seeking information related to copyright infringement. So that's something to keep in mind and something that you should consider when responding and drafting responses and preparing the materials in a format to be submitted to any potential auditor. There are exceptions. The most obvious are for the attorney-client privilege be disclosed to a third party. There is, in some instances, a recognition of common interest exception, and that is where you disclose to a third party, but it's in pursuit of a common goal between two parties seeking the same legal advice or the same information. That is often not persuasive in protecting, so that's not a good exception to use. But generally speaking, if you're copying anyone else, you want to make sure that the clients, when they send you information, are not copying anyone on email specifically or any communication where a third party is involved. That sometimes can include insurance agents. Sometimes we'll have clients who ask us whether their insurance might cover any potential losses or damages related to copyright infringement. So we have to advise them to be very careful about how they communicate and what they communicate to make sure that we maintain privileged documents and all our communications are still subject to attorney-client privilege. As far as work product privilege, obviously we discussed business records and documents prepared in anticipation of litigation, and that will include an auditor hired by a software publisher or your network inventory. For example, your work product privilege is by or on behalf of the client. So if someone else hires an auditor, or if the software publisher conducts their own audit, obviously that information is not protected by work product privilege because that is not someone working on behalf of the client. There are a couple of recent privilege decisions. Obviously, these simply just outline the elements of privilege, which are fairly basic, but something to keep in mind. It's a good refresher to go over these elements every once in a while just to make sure that you're complying and making sure that you're protecting all of your information. Sometimes it's easy to forget in electronic format, especially when you're sending a lot of emails or making a lot of phone calls and not paying attention to who is joining your phone call or who is being copied on your email. For example, if you have a client who just copies a sibling who is unrelated to the case and not just because they're an attorney, and so you kind of destroy that element of confidentiality and you risk exposing your potential communications, which could include important information like legal strategy. So the essential elements you need to keep in mind are it's specifically to seek legal advice from an attorney, someone capable of making legal advice. The communications are specifically related to that and made in confidence by the client and are expected to be permanently protected from disclosure. The client, like I said earlier, the client is the one who holds the privilege, so the client is in the best position to assert it. For work product privilege, USC Textron, they adopted a more narrow test than the typical anticipation of litigation. This stricter standard for use in litigation means it's very difficult for people who are performing a software audit to be able to protect their materials simply because for use in litigation is not necessarily something that would fall under your raw audit materials or your audit results if you don't have a reason to be using those in litigation. Other jurisdictions use because of litigation or just the standard in anticipation of litigation. Because of is a little bit of an easier test. Some of the courts have stated that, once you receive information about potential claims, anything you do specifically for the purposes of that, because of that letter or because of the legal claims, that can be protected potentially with work product privilege. And so that's a little bit of an easier standard, and you would have a little bit more flexibility in the event that that was the jurisdictional standard. But most courts have kind of gravitated towards the more narrow use of it for use in or prepared for the purpose of using in litigation. Anticipation of litigation is a little bit less restrictive as well, but when you're looking at the software audit results, you still have to make the argument that the software audit is not conducted simply as a request where you don't expect any legal ramifications. For example, it might be difficult if the client has been contacted by Microsoft for a SAM audit, software asset management audit, and they make no potential legal claims at that time for any potential copyright infringement. So whoever receives that communication isn't necessarily concerned or aware that it's possible to be pursued by copyright infringement. Any information exchanged at that point may not be protected and likely would not be protected by work product privilege because it's not necessarily an anticipation of litigation because there's no expectation of that at that point. For the more aggressive audit letters that specifically state they have potential copyright claims, that's easier to assert that any work done later at that point, once that letter is received, is in anticipation of litigation because it's not something that would be done during the ordinary course of business, not something that would be generated as a result of just ordinary business operations. The key litigation case for software audit specifically, Columbia Data Products v. Autonomy Corporation. This was involving a software audit conducted by Columbia Data Products. Columbia Data Products had a license agreement with part of Autonomy Corporation's predecessor. Autonomy Corporation involved a lot of sales and mergers, and their predecessor had a license agreement which included an audit provision that allowed an independent auditor. So Columbia Data Products initiated an audit based on the assumption that with the change management there may be some compliance issues. They conducted an audit by hiring an outside law firm who in turn hired the external auditor, PricewaterhouseCoopers, to conduct the software inventory. PricewaterhouseCoopers contacted the client directly, Autonomy Corporation directly, and requested access to their network to conduct the software audit and demonstrated that they were the independent auditor hired as part of the license agreement audit provision. So they conducted the audit, and after a lengthy dispute that is still ongoing, they determined that there were significant discrepancies on software compliance and believed that they assessed a value of total settlement range and past royalties and past copyright infringement damages to be somewhere in the neighborhood of $23 million. Autonomy Corporation disputed this, disputed the audit results, disputed the ability of them to calculate the damages in the manner in which they calculated it, and it was ongoing. And in December of 2012, a preliminary ruling by the court discussed whether or not work product privilege would apply to the audit results. Autonomy was seeking to protect those audit results from being used against them in litigation because they claimed that they were protected by work product and because it was from an independent auditor who was hired specifically for the purposes of conducting the audit in anticipation of litigation. The court determined that at the time that PricewaterhouseCoopers was contacted, that they were not in anticipation of litigation. It was simply an audit pursuant to the license agreement that allowed an independent auditor to come in and conduct the audit. In addition to the license agreement, the PricewaterhouseCoopers auditors were not working on behalf of Autonomy Corporation. They were essentially working on behalf of Columbia Data Products since they were hired pursuant to their audit rights in their audit provision that allow them to hire an independent auditor and generate the data regarding autonomy's installation information. So you have a couple of elements that were missing from work product privilege, and those were the essential turning points of that matter, which is why the court determined that work product privilege did not apply. And so that information was not protected. This kind of highlights why it's really important to assess what your audit rights are, what the audit rights are of the auditing entity, and how that data is being presented. And a little bit later on, we'll discuss ways where you can try to negotiate those provisions to protect your clients and the companies against having to submit this sort of information without any sort of confidentiality agreement or any sort of protection from using that information later. One of the more common litigation issues is related to privileges. You won't find a lot of software audit related privilege issues, but you'll find a lot of financial audit related issues. And Caballero of the United States was one of those. The Caballeros owned a business, and in addition, their sons owned a separate business, and they decided to sell and merge together and then value those companies to determine the sale price and an accurate sale price for each of those. Together, they both used Ernst & Young to conduct the financial audit and give them information and advice regarding the sale and merger. They attempted to assert attorney-client privilege when the IRS sought to discover the information related to their audits. The IRS believes that they had underpaid significantly on their taxes and were seeking information regarding that. The Caballeros attempted to assert the common interest exception to disclosure to third parties. Their argument was that both them and their sons were represented by Ernst & Young for a common interest goal of valuing their companies so they can merge them and sell them together. They also claimed that Ernst & Young was to assist with legal advice related to the financial implications. The court ultimately held that there was not privilege because Ernst & Young did not facilitate communications for legal advice, and that there was no common interest exception because only some parties were participating in the negotiations and the information exchange with Ernst & Young. So unless all parties are participating, the common interest exception does not apply. In addition, attorney-client privilege typically will not apply to accountants or financial auditors except related to specific tax advice information. So if you're looking at clients who have financial issues in addition to their software issues, you're not likely to be protected by the work product or by the attorney-client privilege. So that's something to keep in mind when advising clients on how to protect their information and what how they can view their information and prevent it from being disclosed later in the event of litigation. Further than the protections of the privilege and different privileges, you also have confidentiality agreements, which are particularly important in software audits. The Rule 408 agreement is an interim confidentiality agreement that protects the audit results from litigation if settlement fails. This is not an ultimate confidentiality provision which can be negotiated during the settlement agreement process itself. So this only protects the information submitted to the auditor and protects it from being used in litigation. There are obviously exceptions. For example, if you submit a report that vastly varies from what your client will discuss in court or the installation amount, they can use it for impeachment. They can also seek to discover it, and at that point you have to assert your confidentiality or your privilege and do a privilege protection log and that information. And so it is important to note that it is not foolproof and there are exceptions, but it is certainly helpful to protect the information in addition to any privileges that may apply. As we talked about with the settlement agreement, there are certain provisions that are more important than others. Specifically, when you certify the authenticity of the audit results, this is where you're going to look at your real ethical implications and your strategy decisions on how you present the information. There are many interpretations to license agreements and how those licenses should be applied. There are different ways that you can present the information that is still accurate. And that is why it's important that your client is confident that everything that is reported is completely accurate and part of an accurate representation of their network. Because in the settlement agreement, the release of liability and the other information is contingent on the certification that the audit results that were provided to the auditing entity were accurate and were correct and true and correct as of the date of the initial audit letter. In addition to the interim confidentiality agreement, most of my clients, if I would say 99%, negotiate a confidentiality provision to be included in the settlement agreement. Some choose not to, simply because they do not want to pay the extra premium that the auditing entity charges. Usually it's a percentage of the total settlement, but it will increase the total settlement payment. So some of my clients don't wish to include it. I would recommend that any clients that did not have a confidentiality agreement in place, to let them know the effects of making that determination. We'll often send them a sample press release from the auditors demonstrating, kind of the bad press that you can get related to a settlement agreement that they are free to disclose if there's no confidentiality agreement in place. When we put in a provision, it specifically restricts anyone from disclosing the existence of the settlement agreement or making any press releases or discussing it at all. And so I think that this is an important provision for companies wanting to protect themselves from bad publicity or any negative feedback, especially when it's readily available and easily searched on the internet. Finally, I think that the most important provision for settlement is the release of liability section. This section is what absolves your client of all liability, and it is often made contingent on a few items. It is often made contingent on some obligations. For example, for your release of liability, everything has to be accurate. For the audit results, you have to certify. You also have to comply with some post-settlement obligations, usually the release of a software use policy to all your employees. Also, we try to negotiate, instead of allowing the auditing entity to come into the client's office for an audit, we'll negotiate an annual officer certificate. So this just has to be performed over a couple of years after the settlement is reached, just simply certifying that everything on their network is true and accurate. What you don't want to do in a release of liability section is have a provision that requires a perpetual obligation to exist in order to obtain a release of liability. I had one case where, it was a little bit different language, and the settlement agreement originally the original draft had, a section that required the client to perpetually be in compliance at all times and have, other specific obligations that really went on for the entire future. You want to make sure that you restrict the release to only specific performance of very specific obligations that have a clear end date. Obviously, your client is going to have to warrant as part of the settlement agreement that they can intend to continue to comply with all license agreements, but I would make sure that that's not in the release of liability section if you can help it. It's also really important to make sure that all of the software publishers at issue, for example, if you have a BSA or SIA matter, that every software publisher that was at issue in that audit are included in the release of liability section, and a reference to each specific individual product is referenced. You want to make sure that it's all encompassing and it's clear and there are no loopholes to where it's completely a true and accurate release of liability for your client. For license agreements, typically for the traditional license agreement that you can purchase through different smaller manufacturers or smaller publishers or just small retail items, those license agreements are not going to be very negotiable. You either accept them and install it on your network or you don't. There are large-scale, master agreements that are put in place by very large companies using larger-scale products like IBM or Oracle, where they have master agreements and then subsequent amendments, and they have terms and conditions of the audit itself. There are several key items that you want to be aware of when you're reviewing this information: who conducts the audit, Is it the software publisher themselves, or are they hiring a third-party auditor? How much notice is required? Some require to give significant notice. Others require only 30 days before they come in sight. You also want to look at whether or not the audit results are protected. Is there a confidentiality agreement in place for any of these audits? And depending on the answers to those questions in your master agreement, you want to make sure that you tailor it specifically to your client's needs and you minimize the impact as much as possible. We would recommend that if it's possible to revise it so you can make sure that the client can conduct a self-audit and simply submit the self-audit results to the software publisher and accomplish any true-ups that may be necessary at that time. Your main bargaining power is going to be when you initially negotiate the master agreement. That's when you have a large-scale sum of money being transferred and you have the most power in negotiating. When you're doing renewals, it's not necessarily the best time to make these amendments, simply because unless you're purchasing a large amount of new products and you're increasing significantly the amount that you're spending, software publishers are not likely to entertain any real renegotiation of the terms. And it is difficult, usually a pretty big battle just to get that negotiation started. So it would be best to maximize your efforts when you're spending a lot of money, especially upfront. And finally, I think that one of the more important topics, in addition to just going through and making sure that everything is privileged and protected and you're complying with all of your audit process and you have awareness of what needs to be confidential and how to protect the information, one of the most important things is managing future compliance. Once an audit is resolved, you need to make sure that your client will have a software use policy in place. The settlement agreement usually requires it anyway, but sometimes the settlement agreement has just a very abbreviated policy, and some clients prefer to have a more extended policy to where they can really disclose and outline and educate their employees on how to install software, or what to install or what not to install, and how to use their license agreements. It's important to educate individuals who are installing or who do have administrative access on the terms of the license agreements themselves, since they need to be aware of how you can apply those licenses in order to maintain valid licenses and comply with each of the license agreements. In addition, administrative controls are sometimes very important. We've discussed this earlier, how some people just lock down their network using an administrator where you can't install any software. That is a great way to control what is being distributed on your network, and a good way to restrict your information and restrict any unauthorized software installations. In addition to those controls and the education, it's important to have routine compliance audits, just because, especially if you have a large amount of growth in your company over a very short amount of time, then it's difficult to keep track of how many employees you have and who purchased what and who needs what software. And if you have a lot of growth and you have a lot of new software and new installations on your network, it's difficult to track that and difficult to determine if everyone who has installations on their computers has what they need or the specific type of software that they need. Sometimes clients discover that everyone in the company has Microsoft Office Enterprise and they only needed Microsoft Office Basic. So it's important to not only look at whether you're complying with your license agreements, but also whether your network is set up to where you have what software you specifically need for the use that you have for each employee. And finally, in addition to the routine compliance audits, it's important to have a good record of retention policy, just so you can track the software and any additional licenses that you have and have it readily available in the event that you have an audit or you receive an audit letter. So if you're conducting routine audits and you also are easily able to identify and put your hands on the entitlement information, the audit process is so much simpler because you can review it easily, generate the reports that you need, and be able to supply that information after obtaining a confidentiality agreement to the auditor and have it resolved quickly. especially if you can highlight that you're fully in compliance and simply ask that the auditor close its file. In the event that you are fully compliant and you're requesting that the auditor close its file on your audit, like I said earlier, that they typically won't just go away. What they'll do is sometimes they'll require a certification. So in addition to simply submitting the audit results and proving ownership of all of your licenses, they'll request that you provide a certification at that time that everything is true and correct and that you are fully compliant with all of your licenses and that you have a good software use policy in place. And those are the main key factors for managing future compliance and for managing audits in general and protecting the information. So at this time, I'll turn it over back to Anita for any questions that we may have. I also have, for your reference, if you can't think of any questions right now, my email address and my phone number, so please feel free to reach out and contact me if you think of anything at a later point.